The common law. More precisely, what is it? Now, I've heard a lot of people, a lot of politicians, a lot of commentators talking about British common law, our common law, the common law, this, that, and the other recently. It usually comes up in relation to the obvious failure of the human rights regime to protect the rights of citizens. But what does it actually mean? Now, there are two distinct meanings to the term common law. The first meaning applies to what modern jurists would call case law, and the second meaning refers to the legal tradition. The legal tradition that developed in England and Wales in the mid to late medieval period, and was then exported around the world through Britain, largely Britain and America and other Commonwealth nations. I'm going to explain the meaning of the first connotation, because that's really what it's about. So, common law is case law. What is case law? Case law is the law generated by courts, wherein the judgments of higher courts are binding upon the decision-making processes of lower courts. So, when a lower court is presented with an issue, one of the parties, prosecution level, will say, in the case of such and such, from a higher court, this problem was solved this way, or this legislation was interpreted that way, or this meaning was found here, or whatever. The lower court must apply the rulings of higher courts onto similar and relevant legal matters. That's all it is. And the reason why it's called the common law is because this system of binding precedents, of, to use the Latin term, stare decisis, and yes, law students, I am pronouncing it right, stare decisis, over the generations standardized the legal system, because the higher courts basically created a body of rules and doctrines that were then filtered down into and applied throughout the rest of the jurisdiction. That's all it is. Okay? There's nothing magical or mystical about it. It's just the law created by the courts and applied by the courts from the lower courts, applying the law created from higher courts down onto them. It's sometimes called judicial legislation. It's sort of historically unique because common law judges have a lot more power than civil law judges, because the judges are in effect, within reason and with significant limitations, little lawmakers in of themselves. So, for example, if they're faced with an issue whereby there is no preceding law, there is no relevant legislation, they will often make new rules to fill the gap. Now, these new rules are hopefully based upon the larger body of legal thinking, but they're free to solve the problem as best they see fit. This leads to an interesting characterization of the British legal system, in that our courtrooms are highly not recorded, documented affairs. The judgments of higher courts can be tens of thousands of words long. It's not just a case of writing down, guilty or innocent. It's a case of the judges explaining how they came to their verdict, often citing previous case authorities. And then these judgments are then recorded in law journals, law records, which are then published, and other courts will use them as sources of legal authority. So how did this begin? Well, it all goes back to the Norman conquests. Normans found themselves dealing with essentially a tribal society that was steeped in customary law and local custom and varying degrees of sort of royal decree. They created a single judiciary and had circuit judges traveling the country. And as they moved around, they were standardizing the legal system as they went. So, for example, a man might get fined for trespass in East Anglia at a totally different rate than a man would be fined for trespass in Kent. Well, if you've got a travelling judge, he's going to apply the same ruling he made in East Anglia to Kent, and likewise he would pay deference to his superiors. So it was really the creation of this collegiate tradition of judges, whereby the higher courts, usually staffed by more senior judges, were given greater attention than lesser courts. It's that simple. What it tends to mean is that the common law is historically far more reactive than proactive. All the common law can do is react to the cases put in front of it. It cannot go out into the community and judges tell people you're going to live by this policy. No, it doesn't work that way. It's reactive, and because of that, it's seen the law is seen as a means of solving problems rather than enforcing some grand societal scheme. So it grew organically over the centuries. Problems with the common law is that 1,000 years of jurisprudence, 1,000 years of case law judgments can overburden the legal system, and has historically created problems whereby the legal rules pertaining to, classic example would be theft, were so phenomenally complicated because cases found exceptions for theft regarding this and exceptions regarding that, and nuance and detail. The concept of theft was almost unwieldy, which is why Parliament usually has to step in and then sweep the whole thing away, and came with the Theft Act of 1968. And the other thing you have to understand is that the centre of legal thinking in the UK is not the academic. It sure as hell is in Parliament. It's actually the courtroom. The law is what the court says it is. The supreme power of Parliament is only enjoyed by Parliament because the court recognises Parliament. Now, there are counter-arguments to the origin of parliamentary supremacy, but I think it's fair to say that the courts generated the notion, not Parliament. So it's a manifestation of the common law, the case law, of higher courts saying yes, Parliament's law is superior to everything else. We must accept it. That's where the supremacy of Parliament came from. It was lent to them by the judges. That's a very simplistic view of the origin of parliamentary supremacy. Don't get bogged down in that. But that's one facet of it. And that means that statute law is superior to case law. So if Parliament passes legislation that conflicts with an old common law rule, the legislation has amended or abolished the common law rule. This happened, I think, a lot of the old, really weird medieval common law criminal offences were abolished by Parliament. The offence of being a common scold and all these wacky things from the 1400s, whatever. Parliament washed them away. That doesn't mean that the legislation has absolute power over the common law system, because legislation is dependent on the courts to apply and interpret legislation. So I think of it like the legislation is like the software, but the courtroom is the computer that actually manifests the program as best it can. This is where you get conflicts between Parliament and the courts, because the courts can actually interpret law and apply law differently than it was intended in the Commons. What would be an example? A classic example, the Fraud Act, 2006. The Fraud Act was so broadly written that the Fraud Act jokingly was called the act that outlawed lying. It made lying a criminal offence. What the courts did, correctly in my opinion, is they applied the legislation strictly and conservatively through various, you guessed it, case law precedents that meant that the legislation had to be read in a very cautious way. Otherwise it was nonsense. Statute interpretation is another huge topic, fascinating as it is, but we won't cover it here. So, that's common law as case law. It's the law created by judges, whereby the judgments of higher courts must be applied by lower courts. It's that simple. The second connotation, the common law tradition, the common law legal system, is just the jurisprudence that developed predominantly in England, although you could argue England and Wales, and has been exported to the rest of the world. So it's the Commonwealth, but it's also America. America had its own little empire at one point, so you got common law jurisdiction, I think, in the Philippines, and it's merged and mutated across the world, but it still has that same judge-centric, courtroom-centric approach, whereby the judge should interpret the case in front of him from the judgments of higher courts. There are many other differences, but those are the big ones. Forget all that free man on the land rubbish about common law rights and there's this magic formula. If you say it's all garbage, they're all con men. Okay, common law is just the law of the courtroom. Okay. And for part 2, I'll talk about the differences between the common law legal tradition and the civil law legal tradition. Over and out.